So, Vic, if you were advising Bruce Lehrmann, would you advise him to run this case?
Peter, I don't think so. I would not have advised Bruce Lehrmann to have commenced these defamation proceedings.
Because,
Well, primarily the concern of any of the defendants raising the defence of truth in the proceedings. So that's a key consideration for any plaintiff to any defamation proceedings being brought, but particularly in circumstances where the imputations complained about, meaning the meanings arising from the publications, concern criminal offences and give rise to allegations of criminal guilt. So in raising the defence of truth, it's expected that any trial will delve into the allegations as the defendants endeavour to prove the substantial truth of those imputations and the allegations.
why does it make a difference if the allegation concerns criminal activity?
Well, because it is of the most serious nature. So serious criminal offences are obviously going to be the most harmful, but it's inevitable that as the defence is raised and evidence adduced to support it, it's going to involve evidence being led from various witnesses, documentary material that will be relied upon by the defendants in supporting the allegations made, in demonstrating that they are substantially true. So it does become quite a risk and quite a concern for plaintiffs because it can lend the defamation trial to being seen as a quasi-criminal trial.
The other aspect of that, of course, is that because it's a civil action, even though it concerns a criminal matter, the need for proof is much lower because it's simply balance of probabilities instead of beyond reasonable doubt.
Yeah, so there is a very different onus in civil trials. But the other aspect here is that there aren't a lot of the safeguards that in defamation trials as exist in criminal trials. They are actually, in essence, two very different types of proceedings. Both have their complexities, but in essence, in a criminal setting, there are some safeguards that are designed to protect the integrity of the process. And invariably, media will report on the evidence and the allegations and submissions that are made throughout the hearing. And certainly what the public will see is a myriad of the allegations and the evidence raised by the defendants in support.
Give me an example of one of those safeguards.
So there are some different rules around prosecution, so how prosecutions are run. And of course, they have particular duties and responsibilities. There's legislation that governs how prosecutors operate, what they do, whereas there's no such requirement on lawyers representing the plaintiff in civil proceedings.
I see. So from a communications point of view, the advice we give to people who are planning to run a defamation case is be very careful because your character is going to be trawled over.
Absolutely. Absolutely. You're inviting that scrutiny as to your character, as to your credit, certainly as to the allegations that are made against you as a plaintiff, and whether or not you can be believed on your version of accounts is absolutely key. And so it's not uncommon for, serious credit attacks to be raised throughout the course of any civil proceeding. It obviously turns on the cause of action, but that is something a plaintiff should always bear in mind. The other aspect, of course, is, what media attention and scrutiny will their proceedings gain? And it's not controversial to say that these proceedings, so both the criminal proceedings and these defamation proceedings, have attracted widespread media attention. It's perhaps one of the largest proceedings or criminal law proceedings in our defamation proceedings that I've seen reported for a very long time, and I don't think it's about to slow down.
Yeah, and in fact, because of the controversy around the catastrophe around the first trial, people have often referred to it as similar to the Lindy Chamberlain trial in the sense of massive big questions about the way cases have been run and so on.
Absolutely. And the Australian's been active in that area too. So the Australians been reporting heavily, not only on the criminal proceedings, but what's transpired since from early this year and leading through to these proceedings, the defamation proceedings.
So would you be advising Samantha Maiden and Lisa Wilkinson to be giving evidence, given that they're parties to the proceedings?
Well, it will turn on what the plaintiff raises and proves. So in a lot of proceedings, it's obviously a matter for the plaintiff to open and prove his, her, or its case. Okay. And once that occurs, an assessment is then made as to whether or not it's necessary to lead evidence for and on behalf of the defendants. So really, whether or not I would advise either of them to give evidence will really turn on what's raised, all of the interlocutory processes, which includes things like discovery, interrogatories, and the like, the issue of subpoenas, and seeing where all of that, falls, will really be the determinative factor as to whether or not I would want such clients, journalists, to come along and give evidence. But certainly one would imagine that in the instance of journalists, such as these ladies with their profiles, one would expect that they might wish to give evidence and give their version of what they say they did in order to interrogate and satisfy themselves as to the allegations and the like.
Well, it's interesting because Samantha Maiden's strategy has been to stay mum, not say anything so far, whereas Lisa Wilkinson's taken the completely opposite tack.
That's right. And as we know, there's my understanding is that Miss Maiden remains with the same solicitors as her employer, the media organisation, whereas Miss Wilkinson has elected to seek distinct representation to that of the 10 network.
It's likely that Bruce Lehrmann may suffer massive reputation damage on the way through, but then if he wins the case, of course, it'll change. That will change substantially, although there will still be a residual of people who hang on to what they read in the press on the way through, regardless of the outcome.
That's right. That's absolutely right. And that's one of the key considerations for any individual in commencing defamation proceedings. So, I mean, particularly as reporters and various media organisations report along the way, and say, for instance, there's always a risk of adverse publicity, allegations being rehashed, so that the defamation of concern is kept alive and published over and over again, albeit on a reported basis rather than fresh allegations. But in the end, whether or not someone achieves vindication, which ultimately overcomes and overshadows any harm that's suffered from the original publications and ongoing media reports, is a true consideration for any plaintiff, whether or not the ends justify the entire means and process.
Well, like many Australians, we'll both be watching. It's going to be very interesting. So, Victoria Jane, thank you very much.
Thank you, Peter. Lovely to talk to you.